I am pleased to mention a matter, my lord. I am mentioning this matter upon notice to the other party, my lord.
May I have my lord stand leave to mention a matter, my lord? Yes.
I am praying for a upgradation of a matter which is listed in the monthly list of December, item number 494. My lord, since the beginning they have been deferring the court orders. This is the urgency. I'm relying on the last three orders passed by the Honorable Court, my lord. The very first order was passed by the Honorable Justice Savisachi Bhattacharya on 11 September 2024. My lord was pleased to pass a direction for a filing of an affidavit of asset, but they did not file any affidavit. On the next date, on 10th January 2025, they paid for accommodation for a settlement of the amount. They did not pay any amount. On the last occasion, my lord, order dated 4th April 2025, they did not pay any settlement amount, as well as they did not file any affidavit of asset.
No ground. Yes. Yeah, I was kind of to mention a matter, my lord. This is that section 34 application which your lordship has been finally pleased to hear. OCL, my lord, that matter. Your lordship granted us liberty of a week to file our written notes, but your lordship directed it to file with my lord's officers.
Yes.
Could I get some more time and file on Monday, my lord? Only this much in this. We were to file today or tomorrow, my lord. Just the weekend's time, my lord, if your lordship kindly permits me. They have cited 18 judgments. I need to distinguish each and every.
All right.
I'm great.
My lord, may I be permitted to mention a matter online, my lord?
Yes.
My lord, this is my application under section 37 of the Arbitration and Conciliation Act, my lord. This
Yes.
was being heard by the Honorable Justice Ravi Kapoor when it was under urgent determination, my lord. Since then, it has been released as part heard to be
I can't
listed
hear you,
before
sir.
the...
Sorry.
My lord, I'm praying for a withdrawal of this case. The amount has been settled between the parties, so I'm praying for a
Withdrawal. Call out the list.
Your Lordship, I beg to appeal for the petitioner. I am withdrawing the execution application as the awarded amount has been realized. Your Lordship, I am handing over the written instruction we have received from the petitioner.
Learned counsel for the petitioner seeks to withdraw the present petition since the matter has been amicably settled between the parties. He has placed on record the written instruction given by his client is taken on record. Petition is dismissed as withdrawn.
Your Lordship, in this matter, a warrant was issued. So,
All interim orders, if any, stands. Okay. What?
grateful, Your Lordship.
Lordship, the matter has been settled between the parties. This is my instruction.
एक ऑर्डर हो जाएगा.
Section 9. This
If any. ठीक है. इसमें ये AP है, section 9. The petition seeks to withdraw the present petition. Instruction is taken on record. Same is dismissed as withdrawn.
No, section 9.
Yeah, about it. There's no interim order.
No interim order, Lordship. Lordship, this is for the correction of the order. Only the vehicle number has gone down wrong.
ठीक है. शायद necessary corrections.
Section 14, at now 4. My lord, item number 4, I am for the petitioner. My lord, apropos the direction of this honorable court, the petition has been once again served upon the other side, my lord. My lord, I am only humbly seeking a passover of 5 minutes, my lord. Mr. Banerjee is on legs, my lord. I'm being led by Mr.
I'm
Banerjee.
led by Ritoban Sarkar. He is
But
appearing.
with your lordship's leave, my lord, I'm appearing virtually. My lord, I'm appearing for the respondent. My lord, I'm not opposing to the prayer, my lord, for Passover. Otherwise, I'm opposing the petition. I'll cite the reasons why, my lord.
My lord, he's downstairs. He's just coming upstairs, my lord. 5 minutes, my lord, if my lord will. If my lord wishes, I may start. My lord, the petitioner is running an MSME, two MSME business concerns. However, 2024 onwards, the petitioner's MSME concerns are mostly involved in logistics business in Bangladesh. However, since 2024, due to the political turmoil over there, the business of the petitioner got seriously impacted, my lord. Now, my lord, for the expansion of her business, the petitioner had taken a loan from the respondent, my lord. My lord would find the agreement copy at page number 22, my lord, annexure B. My lord, the arbitration clause is at page number 30, clause 18.
Read it.
My lord, due to the unrest in Bangladesh, the
Read
business.
the clause.
My lord, clause 30, arbitration and dispute settlement. All claims, disputes, differences, or questions of any nature arising between the parties, whether during or after the termination of this agreement, in relation to the construction, meaning, or interpretation of any term used or clause of this agreement, or as to the rights, duties, liabilities of the parties arising out of this agreement shall be resolved through arbitration, which shall be administered by an institution recognized by the Government of India for dispute resolution. Such institution will appoint the arbitrator for conducting the arbitration proceedings in accordance with its rules for conduct of arbitration proceedings under the Arbitration and Conciliation Act of 1996, as may be amended from time to time. The arbitration proceeding shall be conducted preferably through online means or otherwise through conventional means in English language. The arbitral award will be final and binding on the parties. Seat and venue of arbitration, if conducted through conventional means, shall be at Kolkata. My lord, if I'm governed by the arbitration clause here, partly governed by the arbitration clause here, this honorable court has the jurisdiction to entertain the instant application, my lord. However, my lord, if I may come back to the facts of the case, my lord, due to the turmoil, due to the political unrest in Bangladesh, the business of my client got severely impacted, as a result of which she started defaulting in the payments of the EMIs, my lord. As a result of which, the respondent started issuing loan recall notice, a purported Section 21 notice. My lord, I am being led by Mr. Banerjee. Yes, ma'am. The respondent issued a purported loan recall notice, a purported Section 21 notice, which initially we were never in receipt of because the letters were issued at a different address. However, later we received those letters, my lord. We did the Section 21 notice, which is at my lord, may I?
On the last occasion, Your Lordship, the issue, the question that had fallen from this bench was regarding maintainability of Section 14. That was the principal issue. That whether Section 14 in these circumstances would be maintainable. If it is covered by the 7th schedule, Your Lordship has held, that is something that enables the party to directly approach this court under 14(1)(a). I'm sorry. So the only issue was whether this is a circumstance which is covered by 14(1)(a) or not. Now, insofar as the cause of action in this particular application is concerned, this is entirely in relation to an unilateral appointment by the conduct of the parties. Now, I have checked the judgment that is covered by 12(5).
Mr. Banerjee, right?
Yes, Mr. Banerjee.
Mr. Banerjee, the only thing which fell from this court was the scope of 14(1)(a) is very limited. Unless until it falls within 12(5) read with the 7th
schedule,
then this gets attracted, and then we can decide that. But as far as challenge to the arbitrator is concerned on the ground of bias, on other grounds, even non-forum, it should be 16.
Correct.
You go before the arbitrator.
No, my submission is, apropos that, my submission is, it has been consistently held by various courts that an unilateral appointment squarely falls under 12(5). And accordingly, the 7th schedule. Product of I'm carrying 2 Delhi High Court decisions which held this. I'm handing up. And even a very recent Delhi High Court decision, I'll cite your lordship, in Ballarpur Industries Private Limited, where also this has been held. And Predator follows TRF and Perkins. And this is, your lordship will kindly see, I'm citing 2020 SEC Online, Delhi 350. Predator Cable TV DG Services versus City Cable. Your lordship will kindly see, this is a section 1415 application.
Yes.
Now, clause 2, para 2, para 3. The issue was that failing an agreement between the parties, under clause 13.2 of the agreement, they were vested, the company was vested with the authority to appoint, nominate an arbitrator. And in exercise of that, the respondent had appointed Charu Ambani as the arbitrator. And the wording, I will take your lordship. Kindly takes, your lordship kindly takes para 9. Para 9 is the wording of that particular arbitration clause. 13.1, 13.2. 13.2 is really the arbitration clause.
Which para?
Para 9 at page number 3, your lordship.
Yes.
They have set out the arbitration clause and the jurisdiction clause. Now, if your lordship kindly takes 13.2, all disputes and differences whatsoever which shall at any time hereinafter so and so arise between the parties hereto, or in their respective successors in title and assigns, touching and concerning this agreement or its interpretation or effect, so as to rights, duties, responsibilities, and liabilities of the parties, either of them under by virtue of this agreement or otherwise, as to any matter in any way connected with, arising out of, or in relation to subject matter of this agreement, shall at first be subjected to an attempt at resolution by mutual amicable discussion. Thereafter, those lines are important to your lordship. Failing which, the same shall be referred for arbitration by the sole arbitrator appointed by the company. That is the clause which fell for consideration. Now, in exercise of this right, the company, meaning the respondent, proceeded to appoint an arbitrator. The legality of that fell for consideration. The court at para 11 quotes TRF, and especially TRF in turn quotes Bharat Broadband, and they quote Bharat Broadband that any appointment by an ineligible person himself will also attract and carry with it that ineligibility, and it will become void ab initio. That is quoted, if your lordship kindly takes. Now, para 22. That is at internal page 9.
Yes.
Before that, your lordship, in Bharat Broadband, one important, I'm so sorry, my apologies, your lordship, at page 5, para 19 of Bharat Broadband, your lordship will kindly take once. And that discusses the distinction between 12.1, 12.3 and 12.5 and what is the mechanism, which is identical to what has been held by your lordship in the recent judgment at paras 33 to 37 and 41. They say when the issue, may I read para 19 at internal page 5. However, the learned senior advocate appearing on behalf of the respondent has argued section 12.4 would bar the appellant's application before the court. 12.4 will only apply when a challenge is made to an arbitrator inter alia by the same party who has appointed such arbitrator. This then refers to the challenge procedure set out in section 13. Section 12.4 has no applicability to an application made to the court under 14.2 to determine whether the mandate of arbitrator is terminated, as he has in law become unable to perform his functions because he is ineligible to be appointed as such under 12.5 of the Act. Your lordship has held the same thing, that once 12.5 is invoked, then one need not go before the arbitrator under 13. Then they are entitled to directly raise the issue under 14.1a. Now, in view of this discussion, your lordship will kindly take para 22 of this decision, page 9. The issue that arises for consideration before this court is the eligibility of the company referred to in the arbitration clause between the parties to unilaterally appoint a sole arbitrator to adjudicate the disputes between the parties. Now, I raise an identical question. Can the respondent in the instant case unilaterally exercise right to appoint an arbitrator? If so, would it be covered by 12.5 or not? The principal contention of the petitioner is that in view of recent judgment of the Supreme Court in the case of Perkins, the company as provided in the arbitration clause between the parties herein cannot unilaterally appoint an arbitrator. This court finds merit in the contention of the petitioner. Supreme Court in the case of Perkins was concerned with an arbitration clause where the CMD of the respondent was designated to appoint a sole arbitrator. Supreme Court, after examining the said clause, held that there could be two categories of cases. One where the managing director himself is made as an arbitrator, with an additional power to appoint any other person as an arbitrator. And the second, where the managing director is not to act as an arbitrator himself, but is empowered to appoint any other person of his choice or discretion as an arbitrator. Reliance was placed on the judgment of the Supreme Court in the case of TRF, in which the case of arbitration clause fell in the first category. In the case of TRF Limited, the court had held that the managing director was incompetent because of interest that he would have in the outcome of the dispute. The element of ineligibility was relatable to the interest that he had in the decision. Supreme Court, thus, relying on the rationale of the decision in TRF, observed that if the test is the interest of the appointing authority in the outcome of the dispute, then similar ineligibility would always arise even in the second category of case, where it is simpliciter confined to nomination. It was observed that if the interest of the authority has in the outcome of the dispute is taken to be the basis for possibility of bias.
Here, the distinction is waiver.
Your lordship, I'm sorry.
The distinction is waiver.
Yes, only exception is waiver.
Yes.
Here I have taken a specific objection. Now 23, thus following the ratio of the judgment in the case of Perkins, it is clear that a unilateral appointment by an authority which is interested in the outcome of decision of the dispute is impermissible in law. The arbitration clause in the present case empowers the company to appoint sole arbitrator. It can hardly be in dispute. A company acting through its board of directors will have an interest in the outcome of the dispute. In the opinion of this court, the clause is directly hit by the law laid down in the case of Perkins, and the petition deserves to be allowed. Then 24, they make the distinction that in Perkins, the clause empowered a managing director.
But here
They
also,
say that it's a
here also we can make a distinction in terms of the fact that, there's an online portal which is there. So,
the portal has not been chosen.
that's right. That's
That
right.
choice of the portal is also unilateral. I would have understood if I had agreed to a portal, because, Your Lordship, the jurisdiction clause merely states an arbitration institution administered by the government of India, nothing more. Now, if they had given me the invocation notice, if pursuant to that invocation notice, I had agreed, then that would be a waiver, Your Lordship, under 12.5. But I had specifically objected. And now, in line of this, following this, and at 29, the ratio squarely, first and foremost, 12.5 of the Act itself begins with non-obstant. So 12.5, it was held to be impermissible under 12.5. And Section 14 at page paras 33, 34, Section 14 was allowed. Now, since this was a 14-15 application, Justice Mukul Mudgal was appointed as an arbitrator in the instant case. But I'm seeking termination. Now, identical facts, similar facts, another recent Delhi High Court decision, which was issued on 16th May 2025, I'm handing up to Your Lordship.
Yes.
I believe it's by the same honorable judge.
Obviously,
She has followed the same line of reasoning.
any judge would do that.
4 years apart, but the position remains constant. And there are other decisions, Your Lordship. Smash, Mirador, there are other decisions. These two decisions are opposite. I'm not referring to the facts, etc. The arbitration clause is set out at para 2. That again gives the right to the managing director to appoint a sole arbitrator. The findings are at para 11 and 12. In light of the judgment of the Honorable Supreme Court in Perkins and Central Organization for Railway Electrification, and judgment of this court in Predator and Power Grid Corporation, unilateral appointment of an arbitrator is untenable in law. Following the ratio of the aforementioned two judgments of the Honorable Supreme Court, there can be no doubt an unilateral appointment by an authority interested in the outcome of the decision of the dispute is impermissible in law. The clause in question no doubt envisages appointment of an arbitrator by mutual consent, and upon failure by its... So the clause was mutual consent, parties can, but failing a mutual consent, managing director shall exercise. It can hardly be disputed that the company acting through its managing director will have an interest in the outcome of the dispute, and therefore appointment of sole arbitrator will be directly hit by the law laid down by the Supreme Court. Party autonomy and so and so. 12, 14(1)(a) of the Act envisages termination of the mandate of when the arbitrator either becomes de jure or de facto incapable of functioning as an arbitrator. In my view, 14(1)(a) gets squarely attracted in the present case, and the mandate of the arbitrator is terminated de jure. These two cases, it follows the whole gamut of decision. Now, in the facts of this case, they had given a Section 21 notice proposing Sama at page 141 capital A and B, para 4. 141 capital A and 142. To this, in my reply dated 18th November 2025, at page 148 at para 11, and 12, I specifically objected. Para 12, upon instructions, this is to inform you that the aforesaid nomination of Sama towards appointment of a sole arbitrator is neither acceptable nor justified by our client, inasmuch as the said nomination is completely dehorsed the letter and spirit. So I object. And another issue with this arbitration clause was also that it was a departure from the 30 days period. It was 7 days. So I take an objection, but they nonetheless Despite the objection, they unilaterally appointed Sama, which unilaterally appointed Anilesh Tiwari, which I objected to. So this is the gamut of the conspectus of the facts. In these facts, at this stage, my humble prayer is that they are proceeding with the reference. I had shown that a section 17 is pending before the arbitrator. So I'm praying for some injunction from proceeding with the mandate. If your lordship is not disposing of this application at this stage, at least they should be injuncted from proceeding with the reference. Because I then will stand to suffer irreparably if they pass an interim measure. Those are my submissions, your lordship.
Yes, who's there?
Yes, my lord. I'm appearing, my lord, virtually, my lord, with your lordship's leave.
Bhuvneshwari Ugro, your lordship, I had
Yes.
already shown, but since it's an interim order, it's not binding on your lordship. On identical facts between the same parties, an injunction was granted only
It's
for
also not binding on.
that. Absolutely, I will not follow.
Yes.
Yes, my lord, I'll quickly respond, my lord, to my learned friend. My lord, first, my lord, prayer that is being made is an order of injunction. Now, your lordships will kindly note one thing, that today the petitioner alleges to have suffered irreparable hardships, but kindly considers the facts of the case that it's an admitted case of a loan being taken by the petitioner and thereafter default being committed. My lord, good, bad, whatever may be the reason, the terms and conditions of the agreements were clear that in the event there is a default, the respondent, being a financial institution, will have a right to recall the loan facility. It's public money at the first place. Now, my lord, taking this background into consideration, kindly takes the arbitration clause once, my lord, which is at page 30. My lord, the clear copy is there in the petition as well. The clause is it's set out at paragraph
You
10.
just read the clause, sir.
Yes. My lord, I will just emphasize on one thing, my lord. This is not, in my respectful submission, a case of unilateral appointment. My lord will kindly appreciate that the underlying concept, my lord, of not permitting a party to appoint an arbitrator is to ensure party autonomy and to give equal rights to both the parties to an agreement to give their respective choices in respect of appointment of an arbitrator. My lord, that has been the underlying concept starting from TRF, Perkins, number of decisions, the latest being the Constitution Bench judgment in Central Research Organization. Now, your lordships will see the clause clearly states that in the event there is a dispute and differences between the parties, the matter shall be referred to arbitration and it will be administered by an institution recognized by the government. Now, my lord, in my respectful submission, we as the respondent have only referred this dispute to SAMA. SAMA is an online dispute resolution mechanism platform, which is an independent platform recognized by the government of India, used as a platform by not one high court but multiple high courts across the countries. Now, my lord, SAMA also gives, so ultimately we refer it to SAMA. SAMA, being the neutral authority, gives right to both the parties to give their choices of arbitration. And this will be evident from the document itself. Kindly takes up, my lord, two documents I will show. First is page 144. My lord, it's a right. It starts from page 143. My lord, in annexure to our section 21 notice, we have, my lord, annexed the arbitrate a guideline as to what exactly is the mechanism of SAMA. My lord will kindly takes, it starts from page 143, kindly sees clause 5, which is at bottom of page 144.
140?
My lord, 144.
Yes.
My lord, page 144, para 5. My lord, I'm reading out with your lordship's permission. The parties are hereby called upon to mutually select, nominate an arbitrator or select and nominate any arbitrator of their choice from the panel of arbitrators, which is available at the website maintained by SAMA, and share their names with SAMA as well as reply to the email in which you have received the notice within 3 days from the receipt of the notice so that SAMA may proceed accordingly. So, my lord, document number 1 gives a right to the petitioner to recommend or give their choices in respect of appointment of an arbitrator. My lord, document 2, my lord, apart from these 2 documents, there are other documents also which is not brought on record, but we'll kindly see page 193. This is a part of their record at volume 2.
Yes.
But we'll kindly seize at bottom, again, similar guidelines and options given to the petitioner to make or select their choices of arbitrator.
Page?
From panel of more than 5, page 193. It starts at page 193 at the bottom. As per the earlier notice, 3 days time was given to the parties to mutually select, nominate an arbitrator or inform the name of 3 arbitrators of their choice from the panel of arbitrator having more than 500 qualified experienced arbitrators empaneled with SAMA. So, my lord, this is not a classic case of a 7th schedule appointment where we directly go exercise our rights under the loan agreement and appoint a party to adjudicate the dispute differences between the parties. We refer it to an independent organization, SAMA. SAMA then gives right to both the parties to raise their objection with respect to the appointment of the arbitrator. Here, the arbitrator has also given his disclosure. The disclosure is also important. My lord will kindly takes the disclosure given by the arbitrator where he emphasizes that he has no relation with any of the parties. He has never been appointed as an arbitrator in any of the matters. That disclosure was also provided to them. My lord, no objection raised in this regard. So, my lord, this is at max a case where the petitioner is probably apprehending that there will be a case of bias or a reason which may give an event of bias in the future, for which the appropriate mechanism, in my respectful submission, is clearly provided under section 12 and section 13. I'll rely on a decision also in my support, because section 12 says when you're apprehending, my lord will kindly say section 12 once.
Yes.
Now, 12.1 talks about disclosure which is to be given by an arbitrator, so as to enable the parties to know as to what extent the relationship of the arbitrator is compromised with either of the parties, if I may use that particular term. Section 2 entitles an arbitrator from time to time shall disclose to the parties any circumstances. A party, kindly sees subclause 3. An arbitrator may be challenged only if circumstances exist that gives rise to justifiable doubts as to its independence and impartiality. Your lordships will see the petition, not even one statement given on oath as to how the appointment of this particular arbitrator causes any prejudice or any inference of bias, if I may use the word, so far as the petitioner's interest in respect of an impartial arbitration is concerned. Not a single reference. The only case is unilateral appointment. So I'm inferring that there will be some sort of bias. Subsection 3. Then 4. A party may challenge an arbitrator appointed by him or in whose appointment he has participated only for reasons of which he becomes aware after the appointment has been made. This is the exact case which is made out by the petitioner. Now, my lord, we'll see section 13. Subject to subsection 4. My lord,
Yes.
Yes. Subject to subsection 4, the parties are free to agree on procedure for challenging an arbitrator, failing which the next subclause, failing any agreement referred to in subsection 1, a party who intends to challenge an arbitrator shall, within 15 days after becoming aware of the constitution of the arbitral tribunal or after becoming aware of any circumstances referred to in subsection 3 of section 12, send a written statement of reasons for the challenge to the arbitral tribunal. So his recourse, the petitioner's recourse, lies in section 12, read with section 13, which it's a statutory mandate. It gives a right to any party who is doubtful of the fact that there is a reason of any impartiality or independence to approach the tribunal, file an application, and accordingly question the jurisdiction of the arbitral tribunal. My Lord, in support of this contention, my Lord, may I rely upon, my Lord, 2009 SCC Online, Delhi 764.
2009.
Well, I'll thereafter my Lord, show a paragraph from
2009. Sir, 2009 is before that.
Well, I will thereafter show, yes, well, I'll show decisions post Perkins, my Lord, thereafter.
No, I have no quarrel with the proposition that had it been a 12-1, 12-3, then it's a arbitration. My only ground is unilateral appointment. 12-5. That is my only ground. I'm not saying
See,
that
unilateral is, he's not a.
yes, I will let him complete. On my argument is confined to unilateral, and I will just cite the constitution.
Both the judgments you have cited,
Yes.
either it is the company nominee, or here there's a third party. There's a forum which has been picked up. Sama is a forum which has been picked up by both of
Actually,
you.
in the core case, the first core case of 2020, Justice Bhanumati's decision, that considered the issue of panel. And in that judgment, it was held that since railway, identical
We'll see
argument.
that. Yes.
So let him
No, I will rely on, Malad, that is the judgment which is staring at my face. I will rely on that judgment. Well, I will straight away rely on that judgment. Malad will kindly permit me to just place paragraph 24B where this particular question was raised. I will not waste your lordship's time on this judgment since it's 2009. Malad, the question was if grievance of bias can be made under section 14, then whether the grievance can be made directly before the court or the complaining party is required to first pursue measures under section 12 and 13. Or not, the answer is at page 33, paragraph 33 and 35, 4.1. In fact, I will straight up 33, 34.1, and I will just read out 35 because that summarizes the conclusion. The petitioner in the present case has not approached the arbitral tribunal with the plea of bias and has straightaway approached this court. It is not permissible. The petitioner or application before the arbitral tribunal, which will return its findings thereon. The court, before exercising jurisdiction under section 14 or 34 of the Act, would have the benefit of version of the arbitrators and would help the court in arriving at a decision. Now, next, may I rely upon 2024 6 SCC 211.
Yes.
Yes. My Lord, may I straight away invite your Lordship's attention to paragraph 25.
Yes.
Lord, may I, with your Lordship's permission, read, my Lord, section 13, subclause 1, my Lord, para 25. Section 13, subclause 1 of the Act deals with the challenge procedure and enables the parties to agree on a procedure to challenge the arbitrator. By section 13, subclause 2, if there is no agreement, the party who intends to challenge the arbitrator has to, within 15 days, after becoming aware of the tribunal's constitution, or within 15 days, after becoming aware of any of the circumstances referred to in section 12, subclause 3, apply in writing to the reasons for challenge to an arbitral tribunal. Section 12.3, as noticed earlier, states that the ground of challenge to the existence of the circumstances giving rise to justifiable doubts about the tribunal's independence or impartiality. Section 13(3) states that if the arbitrator does not withdraw or the party does not, in absence of the other party agreeing according to the challenge, the tribunal has to decide. By section 13 subclause 4, if the challenge is unsuccessful, the tribunal will continue with the proceedings and finalize its award. Section 13 subclause 5 states that any party can challenge the arbitrator's decision after the award is made under section 34. Thereafter, section para 26 also deals with section 14 when it becomes impossible or there is a failure to act because he has become de jure or de facto. That's the settled proposition. There is nothing pleaded on record apart from the fact that there is an unilateral appointment, because all these cases, product to table, your lordships will note, there the company, the director of the company appointed an arbitrator straight away, who proceeded to adjudicate the disputes and differences between the parties, differentiates from the facts of the present case. So, my lord, the legislative mandate as on date still remains that first, if you are doubtful or you are apprehending that there will be a situation of bias, your first recourse has to be under section 12, read with section 13. Thereafter, if it's something you are able to demonstrate under schedule 7, the appointment is hid by schedule 7, it is only in that particular case that the court will exercise jurisdiction under section 14 of the Act. But this has also been quite settled, starting from HRD versus Gale Corporation, paragraph 12 by Justice Nariman. Now, let me straight away come to the decision which probably will be interpreted in a fashion which is going to trouble the respondent. Lord will kindly takes up 2024 SCC Online SC 3219. This is the court judgment of the 5-judge bench. But I am for a moment not disputing the proposition that an unilateral appointment is permissible, or in this particular facts there has been a unilateral appointment. But that proposition is now put to rest by this particular judgment. A detailed, elaborate reason has been given as to why unilateral appointment is bad in law. May I just, my lord, request your lordships to take, my lord, one particular paragraph. My lord, para, my lord, 131. Yes. Lord, in all these cases, my lord, in respect of government contracts, your lordship is aware that usually it is the government panels which were being appointed as arbitrators, or choices were given to parties to nominate a person from the government panel. My lord, that was the case in the first court judgment, the case in first Volstapin judgment. My lord, in respect of which ultimately the Honorable Supreme Court said that in respect of panel arbitrators, where you are restricting to the panels of officers who are your officers, those appointments will be considered to be bad. Now, kindly, my lord, notes one fine distinction in this particular paragraph. Lord, para 131, my lord, it starts with Perkins. My lord, from the bottom, it would be the 9th line. It starts with Perkins in italics. Para 131.
Yes.
Yes. But may I read out? Perkins rightly observed that whatever advantage a party may derive by nominating an arbitrator of its choice would get counterbalanced by equal power with the other party. The counterbalance will only apply to situations where the arbitrators are appointed by the parties in exercise of their genuine party autonomy. TRF and Perkins have been relied upon on this court on numerous occasions. So, my lord, emphasizing on that, kindly, my lord, visualize a situation. Today, both the parties, in exercise of their rights, with their eyes wide open, having their conscious understanding, signed this particular agreement, even after so many decisions have come in, where they have agreed that we will agree to the fact that we will apply before an institution which is independent. My lord, one of the parties have to refer to an independent arbitrator, whether be it the petitioner or the respondent. One of the parties have to make a choice to apply before an independent arbitrator. The question is whether SAMA is at all independent or it has any control or vested interest exercised by the respondent. None of such case has been made out. One of the parties have to exercise today. So the respondent, in their rightful exercise of their choice under the contract, have, my lord, referred this matter to SAMA. SAMA is a neutral, independent institution, and if given a chance to file an affidavit, will produce all the documents on record to show that how the said institution is recognized by the government of India and other high courts of the country. And the fact that after SAMA taking cognizance of the dispute gives rights to both the parties, that please, here are the panels of arbitrators, please exercise your rights of choosing an arbitrator of your choice. They do not. And what they are attempting to do today, my lord, they are trying to attempt an order, my lord, obtain an order of injunction and sit indefinitely with it, without addressing on the fact that how they are going to repay or how they are going to make good the loss which the respondent has suffered because of the default of the petition. So either way, my lord, my second argument will be, in the event if your lordship is not satisfied today, my lord, let an arbitrator be appointed, and at the same time let the respondents, my lord, the petitioners be injuncted from operating their bank account without keeping aside the sum of rupees 20 lakhs which is due and outstanding. But they cannot sail on two boats today, my lord. My lord, the third judgment I wanted to rely upon, but it may not be necessary. This is just on the proposition that the parties, after accepting the terms and conditions of the contract, cannot resile from the terms of the contract. They have entered into the contract post all these decisions which has been passed, knowing the fact that there is an arbitral mechanism where it will be referred to an independent institution. My lord, they chose not to, my lord, not sign the contract, but they have signed the contract. My lord, will kindly just permit me, I'll just give the paragraph number, my lord, 2004, 75, volume 75, DRJ 154. But here also the challenge involved a mechanism of appointment of an arbitrator, which was subsequently resiled by one of the parties. Not straight away, if your lordship sees paragraph 14. In view of the foregoing discussions, the challenge to the arbitration clause must fail. It is also to be noted that the present is where international tenders are present. The petitioners, having accepted the terms and conditions of the contract, now wishes to resile from the same. It is also significant that in the entire petition, are identical to the facts of this case. At least there is not an iota of suggestion of any bias or unfairness in the conduct of the proceedings. The petitioners have not alleged that they have been denied an opportunity of hearing, or they have not been given advance service of any petition or any application, and that we have been proceeding with the arbitration at our control and at our whims. That none of such case has been made out by the petition.
You have to argue, or you have to show judgments after 2015. The point which is being raised here is whether this is maintainable or not maintainable. You are arguing on the merit of the matter. This you can argue before the arbitrator if you're going in 16. This court has to see whether 14 is applicable or not applicable. So
this is just on the point of contractual, only to that extent, but I have shown your lordships that 2024 Supreme Court decision clearly still lays down the mechanism under which a party is still has the legislative mandate to proceed before the tribunal under section 12 read with 13, unless he is able to demonstrate a clause of schedule 7 violation, which they have not alleged or they have not been able to show. But these are my respectful submissions.
yes.
5 minutes, Your Lordship. I take it that the long and short of the argument is, first of all, 12.5.
Long and short, he has still not been able to convince the court as far as the applicability of 14 or 16 is there.
to just to
I can distinguish those judgments.
I will just then very briefly cite only one thing, Your Lordship. This entire issue, once I allege 12.5, 14 automatically gets invoked. I do not need to show any
No,
practical
but
factual
12.5 on
issue.
the merit of the judgments which you have showed me, I would say that it's not applicable because the fact is that in those cases,
Clause. That's the issue that is running through Your Lordship's mind, right? I anticipated that. The distinction in all of these cases is that all of these cases that I have cited, which I am cognizant of, has an arbitration clause which provides for a unilateral appointment. Whereas the clause in the instant case does not provide for a unilateral appointment at all. It provides for by consent, which in the facts of this case has not been followed. So it is an unilateral appointment by conduct of the party, by conduct of the respondent, because respondent dehoards the clause, in violation of the clause, proceeded to unilaterally appoint. That's the argument.
You go under 16 challenges
No,
before
but
the arbitrator.
may I just say this?
That there has been violation, 30
But
days
ratio-
has not been done. All these aspects you take before the arbitrator.
The ratio, as I cull out from the entire line of decision, starting from PRF Perkins to the Delhi High Court decisions, is what is impugned is the unilateral appointment, be it by way of a unilateral agreement clause or be it by the conduct of the parties. Because what strikes at the root of the locus is the unilateral appointment.
You have to understand that the act or the legislative intent is very clear, where they want minimum interference by the courts.
May I to assuage that particular
is the reason
concern?
why every application should go before the arbitrator.
May I, at the cost of laboring upon this point, may I just show, because core was shown, this issue and the argument that is made is because Sama gave a panel and you gave you a choice to select from the panel, it does not per se becomes an unilateral appointment. Now, para 131 was shown of core. Now, if your lordship kindly takes the ratio, the conclusion of the court, and this issue is set to rest.
I did. It talks about the unilateral.
170.4. What does it say? In the appointment of 3-member panel mandating the other party to select its arbitrator from a curated panel of potential arbitrator is against the principle of equal treatment. In this situation, there is no effective counterbalance. What is the counterbalance? Counterbalance is if you give me an opportunity to independently identify, nominate. If you give me a preset list and say that you only have to pick from this, that in the decision of this honorable court, in the 5-judge bench decision, constitutional bench decision, is categorically held to be against the principle of equality. Now, in the case is even worse. Your lordship is given to believe that they had given us an opportunity. But once Anilesh Tiwari was nominated by Sama, then I can merely object. I cannot appoint somebody. Then Sama retains. So in my humble submission, the issue whether the mere giving a curated list under Sama's panel makes it something which is not unilateral is perhaps incorrect. That will be squarely hit by the conclusion of the court, by the ratio of the decision in 170.4. Because it says any appointment which is confined to a curated panel is no meaningful consensus, is no meaningful party autonomy. Therefore, in my humble submission, your lordship, I agreed to an institution. What prevented the other party from agreeing to an institution which is mutually agreeable between the parties, as opposed to only Sama? The reason is Sama is today given the mandate to do all of the ODRs in respect of this particular finance company. I have shown the previous judgment of this very court. That is the reason. So now, can that be said to be non-unilateral? Because the precise reason, rationale for disqualification and ineligibility that the company itself is appointing also percolates, as has been held by all these high court decisions, percolates to the appointee of the ineligible party. The moment that percolates to the appointee of the ineligible party, the disqualification under 12.5 attracts, your lordship. Then 14 would be maintainable, in my humble submission. Had this been something else, I think that they will act in a biased fashion, as my learned friend had correctly argued, that would be in the domain of 13. 12.1, 12.3 and 13. In my humble submission, this case does not fall under that. The other aspect is, a lot has been said because the arbitration clause mentions administered arbitration which shall be administered by an institution recognized by Government of India. This is actually a reference to 11.3a. And 11.3a has not been notified. No institution today has been notified by the government as something which is recognized. Your Lordship will kindly read 11.3a. Kindly takes 11.3a, Your Lordship. The Supreme Court and the High Court shall have the power to designate arbitral institutions from time to time, which have been graded by the Council under Section 43I for the purposes of this Act. And SAMA is only recognized, as far as I can see from the document, Bombay High Court and High Court of Kerala. And the arbitration clause in the instant clause gives an exclusive jurisdiction clause and a seat and venue of Kolkata. So, Your Lordship, this appointment of SAMA, in my humble submission, I'm not venturing into those because those are jurisdictional issues. I will take them at the appropriate stage if required. What I'm emphasizing is this is not an enforcement or giving effect to in any way the party autonomy or what the parties agreed to under the arbitration clause, the appointment of SAMA. It renders the designation of SAMA as the nominee, the appointment of SAMA itself ineligible, because this was done unilaterally by the party despite my objection. And thus, Section 12.5 is attracted, and accordingly, 7th schedule, Section 14.1a would be maintainable. And that is what has been laid down in 170.4 specifically, that merely providing a curated panel does not cure the unilaterality. And Your Lordship will kindly take into cognizance one fact, and this is something I had no occasion to file a supplementary affidavit to bring on record. On last Thursday, this matter was called on.
Yes.
4th, this matter was called on for the first time. My learned friend appeared, said that I do not have a copy. So I said, very well, I'll serve. I served the copy. Now I find on 8th, an interim measure has been passed against me. All bank accounts have been frozen. On 8th, yesterday. Today we have been informed. So I am urging that there is no scope of any interim order in this case, in this matter anymore. Your Lordship has extensively heard the parties. Your Lordship will proceed to decide the issue and decide one way or the other. If Your Lordship is satisfied that this is a unilateral appointment, my prayer would be Your Lordship will kindly terminate the mandate. Because this cannot go on. This is exactly what is happening in every matter. They unilaterally appoint, Section 17 is filed, interim measure is
There are
passed.
many grounds to urge before the arbitrator. If they have not followed the due, time period, notices.
Your
all those
Lordship
things can
will
be-
understand what is the fate of those challenges. Your Lordship will, and my understanding is procedurally, once 12.5 case is made out, then perhaps I'm not required to, because the entire purport is, what is the point of going before an ineligible forum if it's a nullity? That's the court's jurisdiction. That's why court's jurisdiction is sought to be invoked.
Heard reserved.
Very well.
Not just
I'm deeply appreciative.
170, just one clarification. My lord. My lord, para 170, which has been relied upon, that is restricted to government contracts. The curated panel constituting of railway officers discusses that aspect. So it's only in respect of government contracts.
Nah, but you are to.
Sorry, I didn't follow you, sir. Your voice was cracking.
Malad, so far as para 170 was relied upon for the purpose of contending that it's a curated panel, that was only restricted to government contracts. But para 133, para 133 clearly states that only your government
is the
contracts.
conclusion ratio of the 5 judgments decision. 11.3 bole diyechi to. Very well. I'm deeply obliged, Your Lordship.
I'm deeply obliged.
This is becoming another hire and purchase issue, Your Lordship, everywhere. Anyway, Your Lordship will kindly consider.
Even I'm waiting for that 29A by the Honorable Supreme Court, that that judgment has been reserved.
Correct.
Oh, that will also give some clarity,
Yeah,
because,
absolutely. Very well. I'm deeply obliged.
Lordship, I appear on behalf of the respondent.
Yes.
I'm
Saying that there is settlement talk going
yes,
on.
the
That's why we kept
document
it.
which shows this is not in the part of this record, but the document shows they have this petitioners have already approached the respondent company with a upfront amount of 5 lakhs so far as the dues to be settled by
Yes.
26 lakhs. That is already the document which
Lordship.
shows that is not the part
Lordship,
of
we have
the-
already invoked the arbitration and sufficiency has also been invoked, Lordship. They can challenge, they can make their submission before the learned arbitrator. This line has become infructuous, Your Lordship. They have also assailed the 13-2
one
notice, Your Lordship.
only one aspect in
Yes.
that event.
Yes.
But do you to Lordship kindly
Arbitration has been invoked, arbitrator appointed. Go before the
well,
arbitrator.
one aspect. Well, because before invoking these arbitrations, the a notice has been served upon us where I have objected on the grounds.
Go before the arbitrator.
No, that Your Lordship, the last matters also. That is the issues. The copy of the agreement has not been anywhere served upon us where it has been signed.
Go before the arbitrator.
No,
sir.
these important issues, and the
What
appointment
issues?
also, and the appointment also in respect of
Challenge the appointment before the arbitrator.
section 12(5) and
nine is-
section 12(5) and
I'll dismiss
first
your 9.
proviso. But that cannot
I'll
be.
dismiss your 9 on the ground that the arbitrator has been appointed.
Lordship.
You raise all your contentions before the arbitrator.
No, only one aspect. Only one aspect. Well, Lordship kindly.
So you challenge the order.
The only one aspect, only one aspect before, before your Lordship kindly come to the notice issued to us.
Not concerned.
But the
sir.
notice
This is
issued to us
today
before,
only
before
section 9 is
before
me.
appointing, the
Sir,
notice has been issued.
arbitrator has been appointed.
No, before
Go
appointing,
before
the
the
notice has been
arbitrator.
issued. But that your Lordship kindly see, this.
Sir,
For
whatever it is.
only for my satisfaction, I will not travel, only this notice your Lordship kindly see, and
I'm
that
not getting into anything.
kindly, I
Yes.
will not travel, only one.
Yes, show me.
This that is that page.
Lordship, annexes C. They have not marked the page number. Lordship, it's at annexes C.
Page 32.
Yes, the page number is there, I think.
Page 32.
Yes.
Demand notice.
Lordship, the demand notice under section 13.2.
13.
No. That is not the notice. Your Lordship kindly come to but the annexure A.
Annexure.
Annexure A, this is a page 10. Page 10. They have proceeded twice, in two forums. That is I am not on that. There I have filed. Essay has been filed against this, that 13.4, 13.2, 13.4. That is apart. That apart, this is page 10.
Yes.
Now, page 10 is the invocation of arbitration. Now, your Lordship kindly see against this notice. They have referred to this agreement and no agreement has been served. I wrote to them raising the objection that your Lordship will find that the appointment, if you are going to appoint, that I have an objection because I have not.
Raise all your objection before
before page 20. Your Lordship kindly see page 24. I raised this objection.
Yes.
Page 22.
Yes. I'm seeing it.
Page 22 is my objection for invocation unilaterally. They have already how that has not been dealt with, and that cannot be that is the root. Section 12 subsection 5 and the first proviso, the sole proviso, that given this right, and the copy of the agreement. At least your Lordship kindly appreciate one thing: the agreement has never ever been served upon us.
All right.
That your Lordship
Lordship,
kindly direct. So
first
that
instance,
how can I take these issues before even the arbitration that they have not served upon? But that I have written to them. Your Lordship kindly appreciate this part also. So unless I go through,
I'm dismissing the application.
I am not on that. Your Lordship kindly one thing you have to let them submit, let them furnish the copy of the agreement. Because I have in doubt in the copy of the agreement which has been your Lordship last occasion yesterday, your Lordship taking the point that so far as the jurisdiction of this court is concerned, that has been executed here in their office, in the present office at the Shakespeare showroom.
If you want, I'll give a judgment on that also.
No, but
Seat-
that
seat of arbitration
executed
take to
and the
Chennai.
payment so far as the made, that was made.
Want me to pass an order on the seat of arbitration?
That I am not on that. These section 9 applications.
Section 9, I'm dismissing it.
But the
And if
section
you
9.
want arbitration, seat of arbitration, I'll decide the seat of arbitration right now.
But your lordship kindly appreciate one thing.
Even if the agreement is signed here, the moment your agreement has a clause where the seat of arbitration is there,
copy of the agreement.
today the Supreme Court is very
Your
clear.
lordship, I have detailed
Seat
about
of
this.
arbitration takes care of
We
the
have
venue.
stated that this agreement is signed, but the copy of the agreement.
Sir,
never
what do you want? You want me to dismiss this? You want me to decide on your seat of arbitration? What do you want? I can do both.
But your lordship has
What do you
already have made up your lordship's mind that
It's not about mine. That's the law. There's
What
no
I
question
can
of making my mind.
promote, I cannot, my lord. I cannot.
If
As
you
your
see
lordship,
the agreement,
as your lordship so decide, as your lordship decide.
no, you want me to dismiss it or you want to pursue this
But
before the
that
arbitrator?
event on the score
I'll
that
give you
this,
liberty.
that as because yes,
You take this application before the arbitrator. If I dismiss it, it will prejudice you. That's why I'm asking you again and again.
my lord, as your lordship.
So this application can go before the arbitrator to be decided.
My
Learned counsel for the respondent states that the arbitrator has already been appointed. Full stop. In view of the said development, learned counsel for the petitioner seeks to pursue the section 9. The present application shall be treated as a section 17 application before the learned arbitrator to be decided on merits. Full stop. The present petition is disposed of with the above observation.
my lord.
Let this be section 17.
My lord. My lord. Your lord.
Well, this is my petition, my lord. It was adjourned on the last occasion because there was possibility of settlement, my lord. I was speaking to my learned friend, senior, my lord, on the other side. He was outside. I don't know where he is now. He said he needs another 7 days or so. But I was, my lord, praying if the matter can be kept this week only. If there is no settlement, we would require some orders, my lord.
We can have it next week. Next week.
Can maybe
kindly adjourn it for the
on
week.
Friday, my lord. Maybe on Friday.
On Friday.
Yes, I was pressing for some orders. That's why. If the settlement does not work out,
Keep it
then
on Friday. You keep it next week. Better for you. I can keep it on Friday if you want. It's just that
then, my lord, if your lordship keeps it on Monday, then in that case.
Monday.
Yes, Monday. Monday.
Grateful, man.
Take down. At the request of the learned counsel for the at the request of the parties, let this matter be listed on Monday. Monday.
I was going to pray for, my lord, that your lordship was not very keen earlier, my lord, for a receiver to be appointed, although I am in possession. I have some judgments possibly which is in my support. I will try and impress, my lord, your lordship. In case the settlement doesn't work out.
That Himachal,
my lord. Himachal.
You want the receiver to go and prepare an inventory kind of
inventory, my lord.
We can look into it. We'll see.
If the settlement doesn't work out, obviously for that.
I'm never closed. I sit with the open.
I know, my, that's why I have, my lord, so that your lordship, my lord, can consider that I've got some judgment.
We can consider that.
Oblige.
My lord, I beg to appear on behalf of the petitioner, my lord. This is, my lord, my section 36(3) application, praying for, my lord, unconditional stay.
Unconditional.
My lord, my lord, stay, my lord, why, my lord? My lord, so far as my section 34 application is concerned, I have, my lord, taken 2 points. One is, my lord, if it is a violation of principle of natural justice, then, my lord, your lordship can consider as to whether unconditional stay can be granted or not. So today, my lord, I will only urge the point. I will only try to satisfy your lordship whether I have made out a case where your lordship, on reading of the award or reading or seeing the, my lord, proceedings in manner in which the proceeding has conducted, my lord, has prejudiced me In a sense, my lord, it was in violation of principle of natural justice or not. I will not take your lordships to the merit of the section 34 application, where I would, my lord, argue that the award is in violation of the terms of the contract and other things. I will not go into that. Today, my lord, I will only, my lord, limit my case for the purpose of stay, unconditional stay. Only I'll try to impress upon your lordship whether, my lord, it is a case, if it is there in violation of principle of natural justice or not. But before that, my lord, I must be, my lord, candid enough to, my lord, show to your lordship.
Before my learned friend submit that matter, I will.
I'm placing that. Kindly, allow. I'm placing that. I will be placing that.
MSME Act.
Yes, my lord. MSME Act.
Section 19 is.
I am kindly allow me to place it. Kindly allow me to place it.
So please.
Section 19, my lord.
The MSME award.
MSME Act.
Deposit.
75%. Now, my lord, let me, my lord, read the section, my lord, in its entirety.
Yes, read it. Who's stopping you?
No application for setting aside any decree, award, or other order made either by the council itself or by any institution or center providing alternative dispute resolution services to which a reference made by the council shall be entertained by any court unless the appellant, not being a supplier, has deposited with it 75% of the amount in terms of the decree, award, or as the case may be, other order in the manner directed by such court. So, my lord, pausing here for a moment, your lordship has a, my lord, discretion. 75% is not the absolute. Your lordship, my lord, in case to case, my lord, has a discretion to, my lord, direct us as to whether entire amount or any portion of the amount below 75% also is possible. Now, my lord, before I, my lord, come to the facts of this instant case, I may, my lord, place a judgment of the coordinate bench, where, my lord, coordinate bench was pleased to give unconditional stay only on the ground of principle of violation of natural justice, and then, my lord, I'll just come back to the, my lord, facts. My lord, kindly comes to the second paragraph. The specific contention of Mr. Meheria, learned senior advocate, is that the respondent before the council did not get an opportunity either to deal with the same or explain the implementation context thereof. The circumstances under which such letter was issued, if explained, would not result in making of the award. Thus, the case of unconditional stay of execution proceeding has been made. In view of non-disclosure of document at the stage of hearing, the principle of natural justice appears to have been violated. These observations are prima facie, as the award holder must be afforded an opportunity to deal with these factual aspects. So far as the instant case is concerned, I will try to show the manner in which this arbitration proceedings has been conducted. And your lordship is well aware, under section 18 of the MSME Act, Arbitration Act 1996 has been made applicable. So, my lord, I presume that the arbitration proceedings, my lord, should have been proceeded with the procedure as established under the Arbitration and Conciliation Act 1996. Now, my lord, kindly comes. My lord, in 8/12/2021, they, my lord, say that is at page 161 of the volume 2. Page 161, my lord, volume 2. Before that, my lord, conciliation was going on before the learned MSME Council, and this is the order, my lord, that was passed on 8/12/2021. Subject, my lord, termination of conciliation process as per section 18(2) of the MSME Act 2007, initiation of the arbitration proceedings as per 18(3), and so and so. The conciliation process in the referred matter duly held by the WB State Micro, Small and Enterprise Facilitation Council under section 18(2) of the MSME Act has been terminated without any settlement between the parties. Now the council is going to initiate an arbitration process as per section 18(3), read with 18(4) of the chapter 5 of the MSME Act. Now, kindly comes to the third paragraph. Now, as per section 23 of the Arbitration and Conciliation Act 1996, as per Rule 20 to Rule 12 of the WB MSABC Rules 2016, the supplier unit is requested to submit their statement of facts supporting his claim before the council within 15 days from the date of receipt of this letter. If not submitted earlier, simultaneously communication a copy of the buyer unit, and the buyer unit is requested to submit the statement of defense before the council within 15 days after receiving the statement of facts from the supplier unit with a copy of the supplier unit. Now, your lordship is well aware, whenever a arbitration proceeding is conducted, every day a minutes of meeting is circulated post the malot hearing, recording malot as to what has happened. Now, malot, I have annexed the notices of all the arbitration sitting, that is malot from 160 to 181. Now, malot, in these proceedings, there is malot not a single minute recorded which would show what was actually going on in the arbitration proceedings. Number one, my lord, there is not a single minute which would record the claimant has submitted this statement of claim on this date, and this is taken on record, and in respect of which the statement of defense is required to be filed by the by the respondent, and if statement of defense is not filed by the respondent, my lord, our tribunal should, my lord, give an opportunity or warn that if the statement of defense is not filed, then, my lord, it will proceed ex parte. My lord, there is not a single minute wherein from it would appear that statement of claim was filed, or against which statement of defense is required to be filed, or right to file statement of defense is closed. This is, my lord, one set of it. Now, my lord, your lordship will find there is, in the process, my lord, tribunal has not called for submission of admission and denial of the documents. They have, my lord, not taken any evidence from the statement from the side of the, my lord, petitioner for the purpose of, my lord, avoiding the, my lord, claim. No procedure, my lord, whatsoever has been, my lord, complied with. Now, my lord, kindly sees, kindly, my lord, comes to, my lord, my pleading at page 18, my lord, para 17. My lord, kindly, I will show, my lord, the manner in which the arbitration proceeding was conducted. There is, my lord, no statement of claim which has been filed, and there is, my lord, no indication which document has been treated to be a statement of claim. My lord, kindly comes to para 18, page 18, para 17. In para 16, my lord, I have stated that 8/12/2021, my lord, notice was issued and given time, 15 days time to file statement of claim, then another 15 days time to file statement of defense. Now, in para 17, pursuant to which what happened, a forwarding letter dated 8/12/2021 was given to the petitioner via email dated 14/12/2021, containing a reply dated 16 April 21 of the respondent, copy of submission dated 22nd 9 2021 made by the petitioner, and a copy of reply of the respondent 18/10/2021. However, on perusal of the said document, it does not appear that the same could be treated as a statement of claim, as no specific direction has been made to treat the letter dated 8/12/2021 as a statement of claim of the arbitration proceedings. Moreover, there is not a single minute or any notice given to the petitioner by WB MSFC by virtue of which it could have been comprehended that the forwarding letter dated 8/12/2021 has been treated to be a statement of claim, and as such, Honorable Tribunal has taken the same on record against which the respondent is required to furnish the statement of defense. My lord, inadvertently, my lord, I have, my lord, failed to annex that with my lord, my application. If your lordship, my lord, gives me leave, my lord, I can, my lord, I am carrying, my lord, 3 copies. I can, my lord, show it to your lordship.
Yes.
But from the minute, my lord, I can show, my lord, there is, my lord, no recording, my lord, to that effect, which is the statement of claim. That is, my lord, number one. Now, my lord, I will take your lordship to the statement of claim. My lord, kindly comes to page 47, which is one of the part of the award. And if your lordship, my lord, is kind enough to turn to page 46 from paragraph 3, my lord, the WBFM
Page 46.
46 from third paragraph, they discuss, my lord, the arbitration process. Now, my lord, kindly comes to, my lord, page 47. This my lord, this is my lord, the under the heading submission of the statement of facts by the supplier unit. My lord, I do not know which is the, my lord, which is the one on the basis of which they have stated that this is the statement of facts. Now, my lord, kindly comes to page 48, submission of revised statement of facts by the supplier units. Now, my lord, pausing here for a moment. If, my lord, they have filed this revised statement of facts, would I not be given an opportunity to file my additional affidavit in opposition or additional counter statement defense? My lord, even your lordship, on going through the entire proceedings, your lordship will not find that they have recorded as to when this additional statement revised statements was, my lord, filed, and whether, my lord, any opportunity was given to me to file a counter to that. My lord, the tribunal, my lord, has not framed even any issue.
You are arguing the merit of the matter.
My lord,
this is not a 34. Sir.
So far as, my lord, merit is concerned, my lord, this would, my lord, appear on face of the record. This would, my lord, appear on the
34, sir. You're not arguing.
My lord, so far as 34 is concerned, for 34, my case is, my lord, better. In 34, my lord, I would show, my lord.
Go before 34.
34 not since I have already filed, my lord.
Said principle of natural justice. Tell me the principle of natural justice which has not been followed. Don't tell me the procedural faults.
My lord,
don't tell me the procedural faults.
Only
tell me principle of natural justice.
Kindly, your lordship can consider that if there is no statement of claim, if I am not
statement of claim, you have filed your defense also. There is a statement of claim.
Well, kindly,
whether the statement of claim was properly submitted, not properly submitted, whether the letter has been treated as statement of claim, these are all procedural difficulties, or you can raise that they were not followed, but not here.
Not only
you are asking for an unconditional stay. An unconditional stay, you started with only one argument, that principles of natural justice have not been followed. You have not spoken a single line or shown anything to avert that contention, that principles of natural justice have not been followed.
Yes, my lord, I was
not
not
only arguing on the merit of the matter and nothing more.
Only, my lord, I wanted to show.
Right, you want to argue more? Argue.
No, my lord, no, my lord. Only, my lord.
You want to waste my time? Waste my time.
No, my lord. I just take, my lord, 1 minute. My lord. Only thing that I wanted to show in these arbitration proceedings, my lord, there was no statement of claim. I was not given any opportunity to file statement of defense. There is no issue frame. There is no evidence late. But the award has been rendered. Only, my lord,
what will be set aside? Very good.
For which, my lord, I wanted, but this is, my lord, limited, my lord, submission. But
you have filed your 34. It will be set aside. Very nice. Yes, principle of natural justice.
Lordship can consider at least not from at least not 75%.
Not at all. If you would have not argued, maybe I would have considered. Now, since you have argued, I will not consider. Yes.
Sir, Your Honor, may kindly take page 38. This is part of the report that has been passed, where it essentially records the dates on which the meetings took place and the parties who were represented.
Yes.
The supplier was not there only on one occasion, which is 5/7/2022, and the buyer was not there only on one occasion, barring that they were all present. These are the defense, which it may sound extremely spectacular at this stage, but that is all for the 34 court to go into, as my lord has rightly held. Lordship, I am on a more basic point, that whether this 36(2) is at all maintainable today.
Yes.
Because this is a MSME, and my lord is aware about the provisions of section 19. There are umpteen number of Supreme Court judgments. There is also one by this Honorable High Court. I can place it right now, because this 36(2) in its isolation is not maintainable at all. And even for a 34 to be filed, there is a mandatory provision that 75% needs to be secured.
Yes.
They may have wonderful case on merits. I am not dealing with that right now, because this is not the stage, not the court where I can go into the disputes raised in 34. but even the 34 is not alive, and hence any application filed in connection with the 34, which is in the nature of a 36(2), cannot survive. It's not maintainable. Your Honor, I will be, if Your Honor so permits, Lordship, I can place the judgments. I'm sure my Lord is already aware of the Gujarat State's disaster management judgment.
Not required.
It squarely
Or
talks
take
about
on.
whether the 34 at all is maintainable when the person appealing the award has not even secured that award to the extent of 75.
My lord, but only one because you were not passing in instance for deposit, my lord. Kindly let it be from in form of
Cannot.
DD.
It cannot.
I'm just dismissing your application.
My lord, my lord, only one thing, my lord. If your lordship, my lord, doesn't direct me to my lord deposit, my lord, where do I, my lord, give them, my lord, deposit, my lord? So that is why not this section 36 application, my lord. Even, my lord, to my lord deposit with the code, my lord, I need, my lord, an order. Even for the purpose of depositing, my lord, 75%, my lord.
You don't need an order from the court.
No, then why
For
do I, my lord, my lord, because my lord, the court, the section 19, my lord, or says, my lord, as may be directed by the court, your lordship can, my lord, very well, my lord, direct, my lord.
That is only if you're filing the application. It says that it can be directed by the court. You file it. You're filing execution.
We still have not. We will be filing because we have taken, we have challenged a part of the award where interest has not been awarded. That is separate, but we will be filing an execution. That is my instruction.
Lordship may
As
kindly,
on date, there is no.
may kindly direct us to, my lord, deposit.
I'm not directing. I'll record your submission that you're ready to deposit the entire amount.
Kindly
With the registrar of the original side. You'll do.
Yes.
Let them deposit. You move an application, withdraw the money. You're entitled to withdraw the money.
I am, Lordship, what I was humbly submitting is on a very technical point, because this submission they should have made before the 34 court that they have filed an application, and as a pre-deposit they need to, because it is a pre-deposit.
All right, need a court order, my lord, to deposit. My lord.
Yes,
34,
so that
it's
is
a
the
pre-deposit.
My lord.
34, it's a pre-deposit.
Even more.
You should deposit before the 30 court.
Yes.
You're absolutely right. They have to deposit before
34 is, my lord,
Your
pending, my
Honor,
lord, before your lordship.
deposit.
there
You
is a,
deposit there. Move an application, deposit the money there.
they need to move it there.
They'll move it there.
Perhaps.
This is an application filed by the petitioner under section 36(2) of the Arbitration and Conciliation Act 1996, seeking an order of stay of the implementation and operation of the arbitral award dated 16/4/2024, passed by the West Bengal Micro and Small Enterprise Facilitation Council, which was communicated to the petitioner by letter dated 19/5/2025, in the arbitration proceedings. Full stop. Learned counsel for the petitioner submits that he has already challenged the award dated 19/5/2025 in a section 34 petition.
AP number 12? Or that is AP number 754 of 2020.
In AP number
754 of 2025.
754 of 2025. Full stop. It is further stated by the learned counsel for the petitioner that the arbitral tribunal had directed the petitioner to refund the security deposit amounting to rupees 49 lakhs.
Security deposits and liquidity damages.
And
liquidity damages.
Liquidity damage amounting to rupees 49 lakhs 2,000 and 736, inclusive of interest quantified at rupees 15 lakhs 32,268. Full stop. Learned counsel for the petitioner states that the principles of natural justice have been violated, and thus he should be permitted to deposit he should be granted an unconditional stay. Full stop. Having regard to the fact that the impugn award is an MSME award, this court is not inclined to grant any unconditional stay. Full stop. Accordingly, उससे पहले लिख दो learned counsel for the petitioner has not been able to show that how the principles of natural justice has been violated. Full stop. He has impressed upon this court that the proceedings before the arbitrator were not conducted in a proper manner, and that he was not granted opportunity to defend his case. Full stop. None of the grounds alleged by the petitioner shows that in the petition as well as during the course of argument show that principles of natural justice have been violated, since both the parties were given adequate opportunity to represent before the arbitration council. Full stop. Accordingly, let them deposit the money.
Yes,
We can.
yes, ma'am.
My lord, I was squarely on that because, Lordship, I will indicate, because it will open up floodgates of other litigation, because that's not the method. Because the Act clearly stipulates that is a pre-deposit. They can make the same prayer before 34th court. I cannot disagree to
No,
that.
no, it's about same thing. Ultimately, I'm
Mr.
praying.
Banerjee sitting here. Mr. Banerjee.
Pre-deposit
MSME.
In a,
MSME is a
no, in a 36, no, we are saying in a 36 too, we can ask them to deposit the money before the.
for 34 pre-deposit, my lord.
Yeah.
That is not permissible because that is a precondition for taking up the
They should file it.
deposit it there.
Or in the facts of the this court is not inclined in the facts under the facts and circumstances of the present case. This court is not inclined to grant the relief of unconditional stay of the award. Full stop. The application is
Kindly grant me your liberty to
dismissed.
file an application.
The petitioner is at liberty to file an appropriate application for deposit of the mandatory amount as per section 19 of the MSME Act
in the 34 application
as law prescribes in accordance with law.
That's it, subject to the point of limitation, because I will take that point of limitation there.
In accordance with law. That's why I'm not saying it.
And my lord, so far as principle of natural justice, Lordship will keep it open for the section 34 court to even raise
That is all. You argued this petition as if you are arguing a 34.
I'm so good.
So 8 and 9, my lord. 8 is my section 34 application I've led by Mr. Mitro, and 9 is there.
There was directions for exchange of affidavits, my lord. My lord, both of us are out of time with regards to the opposition. I was only praying, my lord, if your lordship can grant us a week's time to file the reply to their opposition, my lord.
You're just filing your opposition?
They've filed it on, they've served on 5th, my lord.
Opposition, my lord. Only denying
Directions,
dispute, my lord, which is
directions were for 2 weeks, my lord, from 11th of November.
Which takes us to 24th November.
Yes, they've served on 5th November, sir. 5th December.
4 or 4th, আমরা
My lord, এটা
হ্যাঁ ওটা নিয়ে এসছে তো ফাইল করি তো
এটা কোথায় রেজিস্ট্রি নিয়ে
রেজিস্ট্রার রিপোর্ট যে পড়ছি রিপোর্টটা পড়ছি
record goes back to the claimants.
ক্লেমেন্ট না তোমাদেরও দিয়েছে এটাই লেখা আছে আমার দেখার দেখ দিয়েছে তোমার কাগজ তোমায় আমার কাগজ আমায় আমাদের কাগজটা জমা দিতে
All right, just take that. In terms of the order dated 11th November 2025, communication has been received by the learned sole arbitrator stating that the entire arbitral record has been duly handed over to the counsel for the parties. Full stop. The parties also. The same is recorded by the registrar in charge, original side, by letter dated 28th November 2025. Full stop. That's what there's no.
We do not know, my lord, what the registrar's report is, my lord.
The registrar report says the letter is there. Mr. Banerjee states that he has handed over with a receipt from all of you.
But not all. So, my lord,
that's what it says.
Only a part of it we have, my lord.
Only our one
Sir,
part.
the
we have,
learned
the other
advocates
part
appearing for the respective parties have duly received the original pleading as well as documents as would appear from the receipts given to me by the learned advocates. Copies of the receipts are enclosed for your ready reference.
What we'll do, my lord, rather than troubling your lordship with this, Mr. Banerjee and I will have a look at the records, whatever we have. No, we can file it in court accordingly.
File the original. Whatever.
Yes, whatever records we have, we'll file.
Whatever records, my lord, has been handed over to the parties, they can, my lord, file their or my lord, they can file an affidavit, my lord, bring it on record. Yes. Otherwise, your lordship will not have, my lord, the records of the learned arbitrator.
He says he has given everything.
Whatever we have.
Well, we can do one thing. Well, your lordship has been pleased to give direction for filing of affidavit in opposition and reply. Well, they have filed their opposition. Well, we have not filed the reply because they filed it very late.
So have they.
Yes, yes. Instead of filing before 24th November, they filed it on the 5th.
So the first item is you are appearing, so 34. You need time.
Our 34, they are
counsel for the respondent seeks and is granted 2 weeks.
2 weeks.
2 weeks time to file his reply to the affidavit in opposition.
On the key opposition,
so there's no need for a reply. What?
Lord, they've next whatever documents we have, Lord, we'll.
This is
like
our
affidavit.
You have made it
very honest, Lord.
Writ proceedings, you know.
Like there should be nothing
reply,
except the
rejoinder, rejoinder.
Nothing should be there.
Nothing should be there. I mean,
exactly.
This is
well, I tell you, Lord,
practice. I don't understand.
There's no requirement. It can be done away with, my Lord. We can argue purely on the award because, my Lord,
I don't understand this practice.
Exactly, my Lord. I will respectfully submit to your lordship. I have filed an application on section 34. They have filed an application on section.
What more is left?
And nothing more is left. I think, my Lord, on the records of the arbitrator, on the basis of that, we can make our submissions. Any day your lordship fixes, my lord, we shall come and
any day.
These
because the pleadings are being filed, my lord, that's why
lordship sees looks like it's a writ proceeding going on where you're filing replies. You know, you're what? I mean, can you go beyond the arbitral record?
Absolutely not.
Are you going to do examination and admission denial and other things before me?
34 in any events after whatever's been laid down by the apex court, there's hardly any scope.
May I
practically
unimpeachable. First of all, you don't file any affidavit stating that you have put all the tribunal records here.
So we
they
genuinely
should be
do not have all the records.
I think I should.
Lordship can
call
in
for
fact,
the
in
records.
fact,
I will not call for the records. See the letter which I have received.
Yes. We'll have a look at
if I may,
your arbitrator is not very happy.
In fact, my lord, may I submit this? The only other thing, my lord, that can be brought on record is they will file affidavit, my lord, giving the documents which they have received from the arbitrator. We shall file affidavit.
We'll put it in the reply itself.
We shall, my lord, enclose this. That's all that is required. That's all that is required.
That's all.
All right, seeks and is granted 2 weeks.
Well, I'm too sorry, my lord.
Next wale mein seeks and is granted 2 weeks time to file reply.
Ready for hearing any day. Whenever my lord will get ready, I shall come.
Now only
we are ready to argue the matter out.
Today itself we are ready.
Whenever Kobe?
Now next week it will be very hard pressed. You don't finish your arguments. It stretches for 2 weeks, 3 weeks, then.
No, then my lord, what?
I don't want to start anything afresh before holidays.
We did not file anything. That's what Mr. Mitra is saying.
We'll have it in January, Mr. Lord, only one request. I'm led by Mr. Mukherjee. If it could be Mr. S.N. Mukherjee, can it be after 12th, my lord? He's not there.
In January?
Yes, my lord, in January.
After 12th of January.
12 January.
After 12th, we'll give it.
এরকম হয় নাকি? আজ 12 January.
Are you filing? You want to file replies?
He'll file the reply in the
All
meantime.
right. So that order remains listed for listed on the after 12th.
My lord, may I request
14th of January.
Very.
My lord, may I request one thing, my lord? Only direction that is required, with the greatest of respect, I submit to your lordship, is directing the parties, because the arbitrator has said the parties have been given back their documents. We shall file an affidavit enclosing what documents, my lord, we have received from the arbitrator. They will
Let's
file.
not complicate that.
Otherwise, my lord, the records of the arbitrator will not come before your
We
lordship.
have to rely on that.
You have to rely. He has already stated that he has given everything. He says, I've got whatever you have. You must have filed it with the reply affidavit in opposition. What is the affidavit in opposition?
That letter is not there.
That letter has come now.
That doesn't matter. That letter is on the file. I've recorded in the order that letter has come.
You annex it to the reply. Yeah, we have received very well.
But should we file the affidavit in opposition to their 34?
Yes.
Well, otherwise, because
Absolutely. That's how I'm recording the order. In item 9, affidavit in opposition is taken on record.
Lordship. Great. Great.
No, in item
8.
In item 8, affidavit in opposition is taken on record. Learned counsel for the
File the reply.
petitioner seeks and is granted 2 weeks time to file his reply to the affidavit in opposition. Item 9, affidavit, it's already there. In item 9, learned counsel for the petitioner seeks and is granted 2 weeks time to file his reply to the affidavit in opposition.
14 January, your lordship.
14 January.
My lord.
Auspicious day. It's an auspicious day, 14 January.
It's Sankranti.
Yes, that's right.
Great. Lord, I think, my lord, 14th there'll be.
And you want?
No, that is on the 12th. 14th কিছু হবে
18th is a Sunday.
19th then, my lord.
19th we can.
Anyway, grateful.
19th.
Grateful.
Your Lord,
10
item
to
10 to 14, I have instructions to appear for the respondent. However, the copy that has been served on us is without any annexures, and there are 4 matters with the same cost title. We have not been given the numbers of.
We have not placed the loan agreement on record.
We don't have the loan agreement with us. That's the difficulty. This was a stereotype agreement where the arbitrator was appointed unilaterally. I intend to file a supplementary affidavit bringing on record the section 12 declaration, which itself says that the arbitrator has been appointed in several matters, and if there's any objection, he'll withdraw. There have been objections given, my lord. The award reads that no objection has been received. Had any objection been received, I would have been compelled to withdraw from the proceedings. This is his finding, and I have documents to show that immediately upon receipt of his section 12 notice, we raised objection not by 1, by 3 letters, my lord. I want to file a supplementary affidavit bringing on record these letters, my lord. But the agreement itself is not with me, my lord. Since my relevant friend is here, my lord, let them produce a copy of the agreement, my lord, which would show.
We have to see the problem.
Your Lordship, I'm praying for a service of a proper copy of the petition, Your
No,
Lordship.
he will give you a proper copy. Bring the loan agreement.
Very well, Your Lordship. Kindly give me some time.
Loan agreement, my lord, and my lord, whether, my lord.
Where is the seat of arbitration?
Bombay. And within space of 3 sittings and about 30 days, the award is passed, my lord.
So what does the agreement say? Bombay?
But I don't have the agreement with me. The people who they were granted loan, these are, my lord, agreements where, my lord, they have the power to appoint, and the venue is also theirs, my lord. So, my lord, I will have to see the agreement. If they can produce the agreement, it will be useful, my lord.
Agreement has seat of arbitration is a very important aspect now.
But the question of unilateral appointment is beyond doubt.
That's
The
right.
arbitrator himself says.
You have to challenge it over there. Then you have to go to Bombay. You can't challenge it here.
Let the agreement come on record.
Let the agreement come.
Can,
The,
can there be an order, my lord?
the judgment. I'm telling you.
Suno.
I'm telling you because, you have that expression. Read the judgment. The seat of arbitration is the most important thing now. The Supreme Court has clearly laid down that will decide. Signing, place of arbitration have no impact anymore. All that is past.
Well, it kindly directs them to produce the agreement once, my lord, because this has to be, my lord,
Get
on
the
record.
agreement on the next date.
Yes, Your Lordship.
And I shall serve a fresh copy, my lord. I shall.
So, and you want to file a supplementary?
Yes, my lord. In all 4 matters, my lord.
Learned counsel for the petitioner
5 matters.
seeks to file a supplementary affidavit, bringing on record the objection under section 12(4), which he had raised before the arbitrator,
As well as the declaration under section 12.
challenging his appointment and
the declaration itself,
as well as the declaration of the arbitrator under section 12(5) of the Arbitration and Conciliation Act. Let the supplementary affidavit be filed within a period of
within 7 days, my lord.
within a week, full stop. Learned counsel for the petitioner shall serve a copy of the same, advance copy of the same on the counsel for the respondent list next week.
The respondent to produce the agreement, my lord.
Lordship, may I be allowed 2 weeks time to arrange for the loan agreements?
You get the agreement, it comes in one day. Keep it on the 17th. 17th?
Very good. 17th, my lord. Can it be 16th or 18th, my lord?
18th is execution day, so no.
16th if possible.
All right, 16th.
Very good.
Great.
10 to 14. 10 to 14, my lord.
10 to 14. 10 to 14, same order. You're getting the orders right now. Yesterday I saw that you were not able to follow. If you're not following anything, you ask me. अगर कुछ समझ में नहीं आता है आप पूछ लेना मुझसे, ठीक है ना? Don't just write anything. Any clarification, you ask me, please. Right? I'll just come back in 10 minutes.
Lordship, this is my application under section 29A4 for extension of mandate of the tribunal.
Yes.
My lord, the appointment was made on 29/4/2022. And my lord, the pleadings, including those of the counterclaims, were completed on April 17, 2023. The 12 months mandate expired on April 17, 2024, and that 6 months mandate by consent of the parties expired on 16th October 2024. My lord, the arbitration is at the stage where
Yes, can you give the
Yes.
dates again, please? Appointment was date?
appointment was 29th April 2022.
Meetings complete?
Pleadings were completed on 17th April 2023. This includes the pleadings related to the counterclaim.
First extension expired on?
Lordship, the 12 months mandate expired on April 17, 2024, and the 6 months were expired. The subsequent 6 months expired on October 16, 2024.
16/10/2020.
16/10/24. My lord, in terms of the last directions which were passed by the tribunal, after
What
my
is the
lo-
stage?
Lordship, the affidavit of evidence is yet to be filed. The disclosures have been made, admission denials have been filed.
How many sittings?
Lordship, there have been a total of 27 sittings. Lordship,
My lord, only wanted to bring to your lordship's kind attention, my lord, that the claimant has not been diligent in pursuing the proceedings before the arbitrator. They, in fact, themselves are not really interested in bona fide proceeding with their claims. I'll indicate from the averments in the 29A application itself. Lordship will find, my lord.
These are not grounds not to extend the mandate.
Kindly appreciate, my lord. Now the law is quite clear that once the application is filed, the mandate automatically, my lord, the arbitrator can continue with the sittings. They have not approached the arbitrator. The last sitting has been held, my lord. Yes, 29th September, my lord. In 2024. Since then, they have not, my lord, approached the arbitrator for any further sittings. My lord, affidavit direction has been given long back. They have not filed it.
Why didn't
Repeated
you...
occasions, my lord, when they have not paid the fees of the arbitrator, yet they want hearings to continue. We have made applications for the sittings to be terminated under Section 32 of the Arbitration and Conciliation Act. Next, my lord, dispute arises out of purchase orders, sale of goods sold and delivered.
Let's not get into the merit of the matter.
No, my important aspect is they themselves, they are the claimants. They make an application that the purchase order should be impounded for, my lord, payment of stamp duty long before, my lord, the stage of evidence is done. So they have no intention of proceeding with the arbitration. This is entirely done as a counterblast for NCLT proceedings I had initiated in Delhi. I had filed Section 9 application saying that I'm an operational creditor. Money is due by them to me to create a trumped up dispute. They have initiated this arbitration proceeding.
So why should
Lord,
we
should be
extend
nipped
the
in the bud.
mandate?
Lordship, kindly takes page 23 of my application. That is the last minutes. Lordship, in the last minutes,
For 1 year, more than a year.
Yes, my lord.
You have done nothing?
Lordship, the tribunal's direction was that the arbitration will continue post the extension. That is what
not
was
the law, my lord.
that is what was recorded by the tribunal, and we are bound by the
Claimant
direction.
is diligent and they want to pursue the proceedings. They will call upon the arbitrator to hold a sitting.
And my lord, they also have a counterclaim that.
Just a minute, both of you can't speak at the same time.
I'm
Yes,
sorry.
tell me, what are you showing?
Lordship, kindly takes page 24, the recording in the minutes. The last 3 lines, my lord.
Yes.
Accordingly, the claimant is directed to file its affidavit of evidence after obtaining formal extension from the Honorable High Court at Calcutta by 1 week thereafter. The next sitting of the arbitral reference will be held immediately after reopening of the court after the Puja vacation, subject to the claimant obtaining leave of the Honorable High Court at Calcutta for extension of the mandate of the tribunal. This was the direction given by the tribunal. And my lord, it is not the case that we only have our claim. They have a counterclaim which is higher than our claim.
I will withdraw. I undertake to withdraw my counterclaim.
Lordship, let it be recorded that they're withdrawing their account.
So when did you move this application?
Lordship, this application was filed on November 2024. It was listed. Thereafter, they had taken time to file their opposition. After the opposition had been filed, we did not choose to file any reply. Thereafter, it was listed from last week onwards. Last week, it was listed twice. On 2 dates, they had taken time.
I filed their application in November.
They have filed the application in November, but since
do if
then
the
they have
matter is
not
not being
taken any
taken?
steps for continuation of the arbitration, even though the law permits them. They are wanting to impound their own purchase orders on the basis of which arbitration is
Those
invoked.
are matter of merit. I'm not getting into that. Take down.
Lordship, may it be
application.
Lordship, may it be recorded that they have undertaken to withdraw their counterclaim. Lordship, they have undertaken. We would
I will
place
undertake if necessary before the tribunal, my lord. Since
Lordship, I'll
Lordship
place
is extending the mandate, it leaves a whole question open. We will take
Otherwise,
it
why
before
will
the.
they? The present application has been filed under Section 29A of the Arbitration and Conciliation Act 1996, seeking extension of time for conclusion of the arbitral proceedings and publication of the award. First off, this court-wide order dated 29/4/2022 appointed the learned sole arbitrator to adjudicate the dispute between the parties. Full stop. The pleadings were completed on 17/4/2023. Full stop. With the consent of the parties, the mandate of the arbitral tribunal was extended by 6 months till 16/10/2024. It is contended by the learned counsel for the petitioner that the matter is at the evidence stage, recording of evidence, at the stage of evidence, and cross-examination of the claimant's witness.
Yes.
Is
Lordship, we are yet to file their
evidence.
affidavit of evidence.
Is at the evidence stage. Full stop. The mandate of the arbitral tribunal expired on 16/10/2024. Full stop. Learned counsel for the respondent states that the petitioner had not taken any steps and has not been diligent in pursuing the arbitration proceedings. Full stop. He further states that the arbitration proceedings have been filed to scuttle the NCLT proceedings which have scuttle the NCLT proceedings which have been initiated by the respondent at the at Delhi.
Yes.
Full stop. Learned counsel for the respondent further states that the last hearing was
September
done
2024.
on
September 2024, my lord.
so date. Give the date. Was conducted on
5th September 2024.
25th September.
25th September.
25th September 2024, and since then the tribunal has not held any sitting. Full stop. Learned counsel for the petitioner states that the tribunal in its order dated 25th September 2024 had recorded that the tribunal will be holding its sitting only after an extension has been granted by this court. Full stop. Learned counsel for the petitioner states that he had filed an application for extension of the mandate of the tribunal in November. Date
Date of filing? November 2024.
It's a date.
November 29th, my lord.
29th November 2024. Full stop. He states that the matter was pending adjudication before this court. Full stop. Though this court observes that the proceedings could have continued and the arbitrator could have carried on the proceedings without waiting for a formal order of extension from this court in view of the recent pronouncements by the Honorable Supreme Court, in view of the law settled by the Honorable Supreme Court. Full stop. Be that it may, no. The settled position of law in which is that judgment, Perkins?
No, not Perkins, my lord. Allow me one more.
In view of the settled position of law. Full stop. उसके बाद लिख दो, be that it may, this court has considered the rival contention of the parties Full stop. There have been 27 sittings conducted by the arbitral tribunal. Full stop. Upon consideration of the record and the submissions made by the parties, this court is satisfied that the mandate shall be extended for a period of 9 months from today. The learned sole arbitrator is requested to make all reasonable endeavor to ensure that the arbitral proceedings are concluded and the award is published within the extended time period. Full stop. With the above observation, the present petition is disposed of.
May it please us, my lord, appear for the respondents.
I had made my lord substantial arguments in this matter.
Yes,
I had shown your lordship the two claims that had been disallowed, that is claim numbers 1 and 3.
1 and 3, 4 and 5 has been.
Yes, ma'am. Now, my lord, so far as this is concerned, may I will it quickly take your lordship, my lord, once again to the reasoning and, my lord, the law
Yes.
on which I would like to rely.
Yes.
My lord, claim number 1, my lord, your lordship will find is dealt with from, my lord, page 55 of the application.
Yes.
My lord, the initial part records the submissions of the parties, with which I will not trouble your lordships at all. My lord, then, my lord, your lordship will find at page 59 the arbitral tribunal's discussion and decision. I've shown this to your lordship, but I just want to correlate this. Now, well, if your lordship sees, my lord, at the bottom of page 59, it is discussion decision. After studying the documents on record, listening to both parties, tribunal has following points to mention. My lord, I'll just read it once and, my lord, just reflect on the law. Both the parties have agreed that there have been delays in completion of the assigned works by the claimant on account of delay in handover of work sites, traffic restrictions imposed by Kolkata Traffic Police, and assignment of additional works due to employees' variations. My lord, I've shown you lordship's clause 8.3 and show that, my lord, 8.3 operates, my lord, in very limited, my lord, perspective. My lord, 8.4.1 is, my lord, the clause which provides for extension, without providing that in all cases of all extensions, you will not be entitled to claim damages.
Yes.
So, my lord, the first question is, my lord, where is, my lord, the discussion with regard to the ambit of clause 8.3? My lord, if your lordship will kindly come back to, my lord, 8.3 once, that's at page 128.
Yes, yes. In case of delay on the part.
That's right. So, my lord, only 4, my lord, circumstances. It says, my lord, in case of failure or delay by the employer or engineer to hand over the site, my lord, this is 1. My lord, second is to, my lord, give necessary notice to commence works. Third is to provide necessary drawings or instructions. 4 is to, my lord, provide clarifications or to supply plant machinery. These are the 4 facets. And, my lord, please see 8.4.1. 8.4.1, on the other hand, my lord, provides for extension in diverse circumstances that your lordship will find at page 129.
Yes, force majeure and.
Yes, force majeure and, my lord, even otherwise, if your lordship sees C, instruction of engineer to suspend work, then, my lord, G, any other event of occurrence, then, my lord, H, employees variation, which has also taken place. My lord, none of these, my lord, provide that you shall not be entitled to, my lord, extension of to damages in the event of, my lord, time being required to be extended in this regard. Now, my lord, coming back, my lord, to the relevant portion of the award, my lord, kindly see, my lord, here there is absolutely no discussion with regard to, my lord, the scope, ambit, purport of, my lord, the clause. Now, my lord, coming back to page 60, the admission here is both parties have agreed that delays in completion of the assigned task are on account of delay and handover of traffic restrictions, assignment of additional work due to employees' variations. Well, of course, my lord, there are other heads also, my lord, which we have identified, but the arbitrator, my lord, only, my lord, makes a comment on these. Then please see the respondent has aptly submitted that both the parties followed due processes of the contract contained in 12.3, 12.4, and 3.5 of the GCC in deciding the variation process with necessary adjustment to contract price and time for completion. The cost of variation work and the consequent time required for execution was determined by the engineer GC, which obviously would have taken into consideration the additional establishment cost of the claimant, consequent upon the extended time granted for execution of the additional works at additional price. The establishment was used for variation works during low activity in main project. Well, pausing here for a moment. Well, first of all, your lordship has seen that cost of variation. Well, is what? Well, if I reduce the scope of the work, then well, the contract price reduces. If I increase the scope of the work, then the contract price is increased. Well, my overstay variation is something that runs concurrently with the other causes for which the project could not continue with due dispatch. Now, there is no basis on which the tribunal concludes with reasons that no, you have been duly compensated. What is the observation here? The cost of variation work, which is something that will reduce or increase according to the change in scope of work, the cost of variation work and the consequent time required for execution was determined by the engineer, which obviously would have taken into consideration the additional establishment cost of the claimant. Now, this is a conjecture. There is no reason. Here your lordship will find, if your lordship sees, the language of section 31 of the Arbitration Conciliation Act, clearly 31(3) says, arbitral award shall state the reasons upon which it is based.
Yes.
And the law is quite consistent that an unreasoned award will have to be set aside. Now, delving further on this, if your lordship sees the next paragraph at page 60.
Page 61.
Even page 60 still. Please, please come to the next paragraph at page 60. Both the parties have agreed that unqualified extension of times were granted by the respondent after due process of review of the application submitted by the claimant. Now, your lordship will remember that these extensions were granted without imposing any penalty or liquidated damage, accepting the fact that the contractor was not responsible for the delay. Again, obviously agreeing with the responsibility for delays by the respondent employer with due consideration to the relevant contract conditions, especially 2.2 and 8.3. Again, no reasons. Only references to 2.2 and 8.3. 8.3, I've shown your lordship, is limited in its scope, is not an omnibus clause. Now, the failure to appreciate the extent and ambit of 8.3 in itself is non-application of mind. Failure to refer to clauses of the contract, which is the foundation for the jurisdiction that the tribunal exercises, and without reasons. Then your lordship will find, after skipping one paragraph, then, in view of the above, or may I just show your lordship the previous paragraph also? The respondent has submitted that the claimant secured 695 crore work on single tender basis and at updated price in December 2015 to complete the UG2 contract on a diverted alignment which would have helped the claimant in better utilizing their establishment cost. In view of the above, the nil amount is awarded against this claim. And what is the basis?
Concerned with the UG2?
No, not at all. But on the basis of UG2, it says on that basis, nil amount is awarded. Again, completely bereft of reasons. Then, will please see, EOTs have been granted on account of delays under 8.3 of the GCC, has very clear and explicit provision against any damages for compensation. Again, non-consideration of 8.3. Next, the claim is time-barred. No reasons. Then, notwithstanding the claim being inadmissible, so already the preconceived opinion is formed. The method of calculation of claim amount by the claimant is unacceptable. Now, why is it unacceptable? average amount of establishment cost of manpower, machinery, equipment, etc. of 266.29 lakhs per month have been worked out for a period of 95 months, and the same has been extended for the entire period of extension, having period of low as well as optimum activities, which is considered disproportionately high for completion of entire works of just 657.95 crores. But the arbitrator forms an opinion without any basis. Well, he says it's disproportionately high. Well, why? Well, it is high. Well, what is the error in my calculation that I've submitted? No discussion. Now, my lord, the recording is that I have given calculation, but it is unacceptable only is because it's found to be disproportionately high. Why it is disproportionately high? No discussion. Then, my lord, we'll find the next paragraph. From the response of the questions by the claimant and remarks of the respondent, it is noted that level of resources for the baseline program was not specified, and the claimant had free hand in deployment as well as demobilization of resources with permission from the respondent, which was at no time denied in view of availability of work fronts. There has not been any submission on verification of deployment of man machinery. Well, this was because I have not claimed on account of idleness. My claim was on account of administrative cost for overstay at site for more than 5 years. So, completely, off the track. I have not claimed on account of idleness. I have not, claimed on account of, idle time for men or machinery. But, this is what they say. Then, claimant's contention that claim number 1 is not arising out of idling of resources, but is for unrecovered establishment cost, is beyond comprehension, hence not acceptable. Well, completely without reasons. Acceptance of such logic would guarantee additional payment to contractors devoid of any motivation for early completion of a project. Well, if law entitles me, and there's scores of judgments on this, that if today the contract is prolonged for no fault of mine, then notwithstanding the existence of clauses such as 8.3, I am entitled to damage. That is quite settled position of law as on date. I had cited judgments which were not even considered by the tribunal, although recorded as a part of my submissions. And then your lordship will find just 2 more paragraphs I'll point out to your lordship. Bidders do undertake site visit and risk analysis before bidding for a mega metro project, duly considering wide prevalent delays in acquisition of land. All the bidders were aware of the existing contract provisions, and opportunity was available to the bidders in factoring it bid for such delays. Now, pausing here for a moment, your lordship has been shown the pre-bid correspondence, the pre-bid notification, where the representation is everything is ready. The pre-bid meetings, notings are totally ignored. Arbitrator therefore ignores relevant material and evidence and record in making this observation. Then, please come to Roman 7. Claimant has raised a pertinent point regarding inadequacy of GCC clause, not specifying a time limit of EOT without compensation. But the claimant's proposed solution is equally repugnant. What was my contention? That look here, you have said that this is the clause that will operate to deny you any claim for damage. But there is no end date. So that makes it vague. And this is on the basis of a number of judgments of the Supreme Court and of the higher courts. Where your lordship
end date means there's a completion date must be there.
Well, there's a completion date for the contract. So naturally one would expect that today extension of time within the time period of completion is something that would not entitle you to claim damages. And that is exactly what the Supreme Court has held in at least 3 judgments. That beyond the time period of the contract, if you have been forced to continue with the contract for a period beyond that time, then you are entitled to claim for damages. This clause will not operate to ultimately give an undue benefit to the employer. This again your lordship has seen. What is the observation? Claimant has raised a pertinent point regarding inadequacy of the GCC clause in not specifying a time limit to extension of time without compensation. but the claimant's proposed solution is equally repugnant. Why? Reject it, but give a reason. My lord, this is a completely unreasoned, my lord, award. Now, my lord, I will just take your lordship to, my lord, a part of my submissions. Please see page 57. Well, I'll not repeat what I've stated before, but only one thing. Please see page 57, Roman 9.
Yes.
Well, I have referred to, my lord, the judgments in the case of, my lord, K. Satyapalan and, my lord, Suraj Infrastructure. Where has the learned arbitrator even dealt with them? Nothing. Now, my lord, so far as the law is concerned, my lord, here, my lord, I will come to, my lord, OPG, my lord, at the end, but, my lord, please see, my lord, what is the law on the subject? My lord, I have, my lord, really restricted myself to, my lord, just a few judgments. My lord, K. Satyapalan, my lord, your lordship will kindly have a look at. What does this say? May I request your lordship to please have a look at paragraphs 18 first.
What kind of a contract was this?
My lord, this was a works contract. Your lordship will find, my lord, discussion with regard to escalation of rates. Admittedly, the original agreement did not contain a clause for escalation of rates. On the other hand, the supplemental agreement contained a specific provision that the contractor would carry out all further works within the extended period at rates and in the manner agreed to in the agreement and would not claim any enhanced rate for such item of work on account of the extension of time, either due to increase in the rate of labor or materials or on any ground whatsoever. High Court took the view that although the arbitrator had come to a finding that the appellant had to execute the supplemental agreement under force of circumstances, there was no material before the arbitrator to support such contention. And well, this is the matter that Miller ultimately went to the Supreme Court. Now, your lordship will please have a look at paragraphs 32, 33, and 34. Well, there are other paragraphs also, Miller, which discuss the judgments. Paragraph 32, ordinarily, the parties would be bound by the terms agreed upon in the contract, but in the event one of the parties to the contract is unable to fulfill its obligations under the contract, which has a direct bearing on the work to be executed by the other party, the arbitrator is vested with the authority to compensate the second party for extra costs incurred by him as a result of the failure of the first party to live up to its obligations. That is the distinguishing feature of cases of this nature, an Alopi Prasad case and Patel engineering case. As was pointed out by Mr. Davi, the said principle was recognized by the court in PM Paul, where a reference was made to a retired judge of this court to fix responsibility for the delay in construction of the building and the repercussions of such delay. Based on the findings of the learned judge, the court gave its approval to the excess amount awarded by the arbitrator on account of increase in price of materials and costs of labor and transport during the extended period of contract. Even in the absence of an escalation clause, the said principle was reiterated by this court in TP George case. We have intentionally set out the background in which the arbitrator made his award in order to examine the genuineness and validity of the appellant's claim under those heads which had been allowed by the arbitrator. It is quite apparent that the appellant was prevented by unforeseen circumstances from completing the work within the stipulated period of 11 months, and that such delay could have been prevented had the state government stepped in to maintain the law and order problem which had been created at the work site. It is also clear that rubble and metal, which should have been available at the departmental quarry at Manadi, had to be obtained from quarries which were situated double the distance, even more, resulting in doubling of the transportation charges. Even the space for dumping of the excess earth was not provided by the respondents, which compelled the appellant to dump the excess earth at a place which was far away from the worksite, entailing extra costs for the same. In the aforesaid circumstances, the arbitrator appears to have acted within his jurisdiction in allowing some of the claims on account of escalation of costs, which was referable to the execution of the work during the extended period. In our judgment, the view taken by the High Court was on a rigid interpretation of the terms of the contract and the supplemental agreement executed between the parties, which was not warranted by the turn of events. My lord, what, my lord, this case, my lord, says, and my lord, this is a proposition that has been subsequently reiterated and accepted in a number of, my lord, subsequent judgments, is that, my lord, today, you cannot, my lord, ultimately seek recourse to a clause, my lord, which will allow you to take advantage of your own wrong. My lord, that has been discussed, my lord, widely in even subsequent judgments, because the doctrine is nullus commodum. My lord, no party can take advantage of his own wrong. And, my lord, also, when you, my lord, interpose such a clause, my lord, which would, my lord, prohibit a contractor from making a claim on account of, my lord, the defaults on the part of the other party, my lord, this is unconscionable. My lord, the next judgment, my lord, in this regard, my lord, there was a judgment of the Bombay High Court, my lord, which was also cited before the arbitrator. My lord, this is the case of Suraj Infrastructures. My lord, the learned arbitrator has recorded that this is a Delhi High Court judgment. My lord, this is a Bombay High Court judgment. My lord, your lordship, please have a look at, my lord, paragraph 12 first. Petitioner objected to the arbitrability of claim numbers 467 by referring to the condition 11C
Is
by
it
invoking
those arbitrators in your panel, or how do you appoint these arbitrators?
This was at that point of time, a panel of names was given to the claimant, and the claimant had to choose from that panel. So, my lord, there was consensus between the parties with regard to the choice. It is not that I was appointing it. I was giving them a choice
And they
from the
panel.
and they were appointing their nominee from the panel.
My lord, the law, my lord, till then had not been clarified.
This was quite some time back.
That, my lord, you cannot really, my lord, have your own panel and, my lord, your own arbitrators in place. So, my lord,
That is, my lord, that went on for quite some time. Even in the Delhi Metro case also, this system was approved.
Correct.
That because I am not giving you a
But that is how it was.
Yes.
I mean, this has only developed recently, like
recently.
yes, yes.
Yes.
Well, may I just, my lord, complete this judgment,
Yes,
my
yes,
lord, very
absolutely.
quickly. My lord, your lordship, my lord, kindly skip over, my lord, some of the paragraphs I would have liked to show, but my lord,
I'm in no hurry.
my lord, the petitioner, my lord, 10 paragraph 13,
Yes.
the contention was that the claims are barred as per the agreed conditions itself and therefore is outside the jurisdiction of the arbitrator. My lord, this was the contention. My lord, the rest of the paragraph is not relevant. Please see 15 now. In the present case, important aspect is the delay and default caused by the petitioner. The finding is given by the learned arbitrator based upon the material available that there was substantial delay caused by the petitioner, though the time was the essence of the contract. The work was supposed to be completed within 24 months. Therefore, the basic requirement of availability of site and commencement of work ought to have commenced simultaneously. Then please see paragraph 17. Well, a reference is made to the decision in Ramnath International. Well, if your lordship, my lord, skips a few lines and comes to, my lord, the sentence beginning with the word the moment. The moment terms and conditions are agreed, both the parties are under obligation to perform their part. Any delay on the part of one party definitely delays the whole project. It is difficult to accept the case of the petitioner that irrespective of these circumstances, the contractor is bound to complete the work as agreed, and even if time was granted, there was no question of any claim on the ground of delay and no question of escalation and or increase in the price. Then your lordships, please have a look at paragraph 21. About the last 5 lines of the paragraph. The tribunal proceeded after completion of work by treating it to be arbitrable. The award so passed, therefore, based upon the material, the contention of the petitioner that they are not liable to pay on the ground of extension is untenable. The normal delay cannot be equated with such delay and or hindrance caused by the petitioner. In Ramnath International, the Supreme Court judgment of K.N. Satyapalan was not referred and considered, where the apex court has held that if there is delay in execution of contract due to the conduct of the respondent, that itself is arbitrable matter and he shall be liable for consequence of delay, namely increase in the price. The claim so raised cannot be stated to be beyond the purview of the contract. And then paragraph 27, my lord. Again, my lord, reference is made to K. Satyapalan.
In every matter, it is difficult to say that the tribunal and the court is prohibited totally to grant the compensation. If the case is made out and proved that the delay for execution of the work was due to conduct and or act of the other side, then, my lord, apex court has, my lord, case Satyapalan has been quoted. And finally, paragraph 29, in the result, the escalation price to awarded on the basis of delay and consequential termination by the employer is upheld. Now, my lord, therefore, my lord, what is, my lord, approved is if there is a delay, my lord, on the account of, my lord, the employer, and the contractor is not held responsible for the delay, then, my lord, for any prolongation of, my lord, the period of the contract, consequential loss and damage can be claimed. Now, my lord, two arguments. One was the scope of 8.3 was not considered. My lord, broadly clubbed as if it's an omnibus, my lord, clause. And the second, my lord, the law is not even adverted to. My lord, this line has thereafter received the approval of, my lord, our High Court, my lord, in two judgments, my lord, which I'd like to show to your lordship. My lord, of course, these judgments, I must say, were not, my lord, cited before the tribunal. But, my lord, law in this regard has been made extremely clear. My lord, first, my lord, proposition is that, my lord, these, my lord, no damage or exclusion clauses are to be very strictly construed. So you can't, my lord, read 8.3 as if it's an omnibus clause. The second proposition is that, my lord, so far as this is concerned, this cannot, my lord, extend beyond the period of the contract. So, my lord, today, if you get an extension for performance of a part of the work, but within the contractual, my lord, period, then, of course, my lord, there may not be any imposition of any damage, claim for any damage. But otherwise, my lord, you're entitled to make that claim. My lord, I will, my lord, like to show those judgments. My lord, may I come back tomorrow? 2 o'clock, my lord, is a little difficult. If your lordship has some time tomorrow, I'd like to finish this one. Well, let it be in the list. I'll take my chance.
Okay, let it be in the list. We'll see.
Yes, madam. I'll take my chance.
Heard. Learned Senior Counsel, Mr. Jishnu Saha. List for further arguments. Tomorrow.
Yes, yes.
2 o'clock today, actually, I'm in the division bench.
I see.
If I finish the division bench, I can come back.
My lord, if, my lord, there's a matter fixed, my lord, at
Already fixed.
3 o'clock. My lord,
All right, then we'll have-
my lord, if I am there, my lord, I'll come to your lordship's court and take a chance.
So then I'll come back only for this.
No, there, please don't. There, please don't, my lord. I don't want to make a promise which I can't keep.
Then we'll have.